cake, they usually don't mix well in my experience. Usually when somebody says, we're going to have cake at the end of the day, I find a portal and get away from there. But anyway, so my name is Mehmet Munur. I'm one of the partners at Tsibouris & Associates, and this is Dino Tsibouris.
Thank you very much for having us back again this year. We really appreciate the chance to talk with you.
And so last year we were here. I'm sorry, you'll see me. I would love to be able to do that, but you're not going to be hearing me. So, all right. I'm afraid the recording one is not going to make up. All right. Good. So last year we were here, and we were talking about a possible federal data breach notification law. That didn't happen. We were hoping it would. It would have made life easier for all of us. And we also talked about contracting in the cloud. I'm hoping that was useful for some of you in the past year. And this year, we're going to be talking more about legal perspective on data security. But before we do, we've got even better Dilbert curtains for you this year. So we've Uberized our slides for you. And hopefully some of the acronyms you will use make no sense whatsoever. But remember, at the end of the day, it's about the journey. So let's get started on that journey. We're going to be talking about, look back at 2015 and some of the data breaches and some of the lessons to be learned from that, as we did last year. And then we're going to look forward, and we're going to find out that the regulators are getting more and more technical. And then we're also going to find out that enforcement is expanding in terms of information privacy and security. And then we're going to look at some state information security guidelines. Then we'll talk briefly about how to prepare in the event that you have a breach, how to address some of those issues. Then we'll also touch briefly on information security issues as well.
Just real quick, I was curious to survey all of us in the room. How many of us, just by line of business, how many of us are involved in healthcare? Anybody here in healthcare? So we got a few there. How about financial services? Got some financial services. All right, great. Government sector? Anybody in government? All right. Government contractor. Okay, so a lot of government contractors. Not surprising given the geography. But it is interesting. We got quite a mix. I think we have everything covered here.
Right. So looking back at 2015, you'll recall some of these names. Anthem was a big breach. There were some ties to foreign hackers. Deep Panda was mentioned. The OPM was another big one. Those of you working at the government or working for the government were mostly affected by this and the scale of it. Ashley Madison is again in the news just this past week. I think their slogan is like "Life's short, have an affair with a bot." So it was revealed this week that the FTC is coming after them, and what they finally admitted this week was that most of the females that were on the site were in fact just bots.
Again, it's not illegal to use bots; you just have to disclose it. See, there's the issue right there.
Right, and the FTC is likely coming after it for several reasons. The bot thing is definitely one, because you haven't disclosed it. You think you're having an affair. You're not. It's just a bot. People are going to be disappointed. There is some consumer harm there. The other one is people paid to remove their accounts from Ashley Madison, and that in fact accomplished nothing, and your information was still breached there. But also the fact that they had a data breach, and they claimed that they had the appropriate privacy security protections in place, and they clearly didn't, is going to be another reason why the FTC is going to be coming after them. But you probably will not hear about the final conclusion of this FTC investigation with Ashley Madison for some time, another year at least, I want to say. And the other issue is Wyndham. We talked about Wyndham in the past simply because they are the only company to have been investigated by the Federal Trade Commission and fought it in court. Fought it in the district level, then appealed it, and lost it in both cases, and then they finally settled it. So I think that we're hoping to say that, well, the Federal Trade Commission has to pass regulations before they can go about talking about and enforcing privacy security guidelines, and overruled this FTC enforcement action, but they were not successful. The FTC ended up winning in both cases, and what they ended up accomplishing is to make concrete FTC's authority to bring privacy and security enforcement actions in this area. And some of the other commonalities you will see in these enforcement actions relate to also the effect it has on the C-level, right? The director of OPM resigned, CIO resigned, Ashley Madison, CEO resigned. So there are definitely effects of data privacy and data security breaches on the C-suite, and it should be something that's discussed at a board level and prepared for at the board level, and that's why we have attorneys like ourselves come talk to you about this kind of stuff.
It goes to show you that it's a corporate governance issue. It's not just an IT issue. It's not just a data issue. It's not left to the nerds of the computers anymore. Now it's affecting the people in the C-suite, such that it's corporate governance, which is very helpful because a lot of times when you're dealing with information security, there's a spend involved. You have internal resources. You may need to add people. You may need to hire contractors to round that out. It's really hard to get a budget authorization for something like that because it doesn't really make money until it affects the company and they're paying fines and you're seeing people at the board level having actions taken against them, especially if there's a failure to disclose or a business practice that they knew or should have known about. So we're slowly moving into an area where it's affecting more than just the people on the front lines that have to keep the Huns at the gate away.
Yeah. Having said that, let's take a look at the expanding enforcement areas. He's going to be talking a little bit more about what the FCC and the SEC have been up to in these areas.
Yeah, it's interesting because a lot of the clients that we work with are predominantly healthcare financial institutions governed by HHS and Office of Civil Rights, or Graham Leach Bliley, where you have the different bank regulators, or state regulators even. But what we're seeing now is all the other agencies are realizing a number of things. Number one is that there are issues they have to deal with in their particular area of jurisdiction. Then there's also an opportunity to become more important, if you know what I mean. Because at the end of the day, what good is a regulator if you're not regulating something? So because of that, we're seeing an increase in the other alphabet agencies getting involved with things. So let's take a look at the FCC, for example. There is a proposed broadband privacy regulation that is going to be possibly more restrictive than anything offered by the FTC. Recently, Verizon had an enforcement action against it that involved a $1.3 million fine for super cookies that were imposed on users that were not removed, and it would allow tracking of others in violation of the FCC's 2010 Open Internet Transparency Rule in Section 222 of the Communications Act. And it imposes a duty on carriers to protect their customers' proprietary information and use the information only for authorized purpose. It also expressly prohibits carriers that obtain proprietary information from other carriers to use the information using information for purposes other than what they disclosed. That's not a different fact pattern that you would find in anything else, right? You disclose what your practices are, you have to act consistently with it. But now we're dealing with mobile enforcement. But it's kind of interesting, right? This is a little bit late in the game because we've been having mobile devices and smartphones with cookies and tracking for quite some time now. This is one of the first enforcement actions saying that what we see in the online world for computers now applies to your mobile device, which makes perfect sense as the majority of people that are 25 and under are now accessing the internet by mobile devices, by phones, by iPads and whatnot. Additionally, beyond the FCC, we see regulation by the Securities and Exchange Commission. This is an interesting situation because the SEC has its own privacy rule, right? It has Regulation SP. And there's an enforcement action against a company called Artisys. And in the settlement order, the SEC found RT Jones Capital Equities Management, an investment advisor, willfully violating the safeguards rule from September 2009 through July 2013 because the firm stored unencrypted, sensitive, personally identifiable information of clients and others on its unencrypted third-party hosted web server. So the SEC takes its first step with this enforcement order. It took one just recently against Morgan Stanley. It's a $1 million settlement for a misappropriation of sensitive data for approximately 730,000 customer accounts. And this is one of the challenges when you're dealing with insiders, right? What do you do when the problem or the breach of security comes not from somebody from the outside trying to penetrate or use social engineering to get access to the system, but you have internal employee misuse. And I think this is kind of interesting. The SEC found that Morgan Stanley violated Regulation SP due to its failure to implement sufficient safeguards to protect customer information. So here, according to the SEC, Morgan Stanley lacked reasonably designed and operating authorization modules restricting employee access to only customer data that the employee had a legitimate business need to access. And that's something that's not particularly new. Access controls are very important, whether you're dealing with HR or financial accounts. A person that has access to customer information should only have access to that type of information within the scope of their authority. So a manager over a group of employees in one particular division that doesn't have any other management authority should not have the ability to see other employees that are managed by other people on their SAP system or on PeopleSoft or something like that. Well, the same thing applies in financial accounts for SEC broker-dealers. So here what happened is kind of an interesting fact pattern. They had a particular financial advisor with the firm who was able to access sensitive, personally identifiable information relating to the customers of other financial advisors, not just his own, but other customers for other advisors, including full names, phone numbers, street addresses, account numbers, account balances, and securities holdings. But it gets better. After he accessed this information, he was then able to avoid their internal security controls, restricting copying of data onto removable devices like thumb drives and whatnot, by simply accessing his personal website, which was his own name, GalenMarsh.com, which had a feature that enabled him to transfer the information from his personal computer, from his work computer to his personal server through the web page, as opposed to a removable device. The information was then subsequently offered for sale on at least 3 sites in exchange for payment in speed coins, which is a digital currency. And the investigators believe that a third party probably hacked his server and copied the information that he had stored there, leading to the illicit postings. So we found the enemy is within. And I don't think that's an uncommon situation. What I find interesting is here's a guy who purposely got around the access controls you would normally expect, right? No thumb drives, no other types of storage media should be able to attach himself to the network. Here he just did it by using his own personal web page and uploading it that way. So controls are important. And so here you have the SEC moving into this particular area to give an example. And I think what's really interesting is that a lot of these agencies regulate by creating a rule and then entering into enforcement actions where they sue a company for violation of that rule and enter into a settlement. What'll be interesting is when they stop finding companies and start holding individuals responsible. I think that's when people will get their attention. But until that happens, I don't think we're quite there yet. I think those are 2 good examples of recent settlements. There is a current notice of proposed rulemaking that would allow, going back to mobile content for mobile providers, is a current proposed rule that would allow broadband providers to use and share customer data in order to provide broadband services, for example, to ensure that a communication is destined for a person that actually reaches that destination for other purposes. That would allow for broadband providers themselves to use customer information to market other related service subject to opt-out approval. So I think it's important to look not just at the existing regulations, but to understand that in areas such as broadband communications, mobile communications, the SEC, all the alphabet agencies are getting into this space, not just for privacy, which deals with policies, but also for security relating to controls, relating to the marrying of the two. So keep an eye out. There's going to be a lot of new regulation and a lot of new enforcement coming to a company near you.
Right. One point I'd like to add with respect to this expanding enforcement in this area, Dino talked about access controls, and that's something on the top of mind for regulators for quite some time. And I want to say about a decade ago, if you had this kind of an access control issue where an employee shouldn't have accessed the information they were accessing or shouldn't have accessed the number of records that they were accessing, you would have had an enforcement action, but you probably would not have received a fine. But now the appetite of the regulators for this kind of behavior has changed. Not only are you going to have an enforcement action, you're also going to have pay a fine. $1 million for Morgan Stanley Smith Barney. Isn't it strange, by the way, how the name keeps on expanding, kind of like law firms, as they add, as they go under, add another one, as they go under, add another one. But anyway, so that's one thing that we'd like to note. The other part that Dino mentioned about broadband issues is it's not, unless you're working for an internet service provider of sorts or your Verizon's carriers, this is not something that directly affects you, but it affects us as consumers. This is the FCC stepping in there in the same role that the Federal Trade Commission used to and saying you need to have ground rules with respect to privacy. Here's what you can do with respect to individuals' information that they're collecting on a regular basis. The kind of behavior that they're trying to limit, I guess, is the kind of behavior that you see from Google and Facebook, where you provide them with their personal information, and in return you get ads. But at the same time, these are companies that are providing us with services, and we're paying for them, unlike Google and Facebook that may be free. And now they want to insert more ad-based, more analytics-based services and expand their services. Go ahead. Right.
Well, let's repeat the question. For those that might not have heard it, let me make sure I get this correctly, that you're seeing companies like that using the information for their own business purposes without telling people how it's going to be used. Yeah, definitely there's a problem with that. The idea that you have a relationship with, as a consumer, with another company, if I'm obtaining a service as a consumer from a company, there's a contractual relationship. And under that contractual relationship, there are going to be certain obligations that arise. If there is a contract that company provides to me, whether it's by a click-through or a set of terms or something that they make visible to me in a way that I can see in advance what they're going to do with it, if they disclose it, then they have to abide by that. If they don't abide by that and make changes without getting my consent, they would be open to a number of different claims. For example, if you're regulated by the Federal Trade Commission, if you make a privacy representation and then you use the information for different commercial purposes than the one you disclosed, that would be a deceptive trade practice under Section 5 of the FTC Act, and they could bring an enforcement action against you for that. They could also use your information in a way that is, and we'll look at this in a few minutes about what an FTC enforcement action looks like. They could use your information in a way that is deemed unfair, that they're not just deceptive in what they say, but they're using that information unfairly against you, and that would be another form of a violation of federal law. The disclosure is very important, so if you say something and it's untrue, then you're legally liable for it. The problem is that if you don't say anything at all, then in a sense it's kind of buyer beware, isn't it? And I think that's some of the challenges, that when you look at some of these terms of use, they're not necessarily opaque for small startups and companies that offer an interesting service, but you try to read how they're going to use the information. If they don't say anything, is there an agreement? Is there anything deceptive? So it's like if you don't say anything, it can be a little murky. But I think what these cases stand for is that if you make promises that you will only use information for the disclosed purposes, and you use them for a different purpose than the one you disclosed, you would be legally liable and you could pay a civil money penalty.
Go ahead.
What if they have terms in there, like EULAs, that basically say, we're going to disclose to you that we're not going to disclose to you? Things like, these terms may change at any time, and you're not even, you know what I mean? Those type of things.
Right, right.
The EULA.
Yeah.
It goes here, and then at the bottom it says, we hold the right to make changes to these terms without notifying the user within blah, blah, blah. So they're basically disclosing to you that they're not going to disclose to you.
I think there are several avenues of recourse for a consumer with respect to an issue that you're describing like that. There's at least one case law in Texas that holds that kind of a provision in a terms of use, wherein you say that I will revise this agreement whenever I feel like it is against public policy and cannot be enforced. So that's going to be the first issue that you're going to run into, and you're going to have class action attorneys that are going to be finding a kind of harm, as you would in this Verizon case that we talk about, wherein Verizon inserts changes the HTTPS headers, creates super cookies that cannot be modified or deleted by the consumer, right? So there's that recourse from a class action perspective. The other issue that you're going to run into is even when you disclose everything that you're supposed to and you hide it away in a EULA or terms of use or a privacy policy, doesn't necessarily make it enforceable. And the FTC had an enforcement action against Sears where you could install an Internet Explorer add-on and it literally tracked everything that you did on your computer, including SSL encrypted communications. And it was scraping away users, usernames, passwords, email addresses, social security numbers, whatever you answered. It was basically a keylogger. But you opted into it. And Sears disclosed, hey, here's basically what we do. But they kind of buried it, and they didn't disclose it in as much detail as in the just 30 seconds that I can describe to you by using the word keylogger, right? And they had an enforcement action against them for deceptive and unfair trade practices. So some of these practices, the kind of practices that you're talking about, if the FTC knows about it, and if there is some sort of consumer harm, then the FTC will go after those kind of companies. And there is also a burgeoning industry. Well, it's not burgeoning, it's just a mature industry of class action, privacy and technology attorneys who go after smartphone, smart device manufacturers for security or privacy issues that they may not have thought about when they were rolling out that. And we'll get to talk about some of those later on.
If you summarize all the cases on sneak wrap where they try to slip in a change in terms or something that's invasive or unusual, the courts generally will enforce unusual but otherwise legal permissions for using your information to the extent there is a degree of prominence to that. So there might be a summary page that would help, or the terms need to be bold-faced and moved higher in. The case that Mehmet was talking about was down in paragraph 20 in small point font, and the court said that's not, the result of that was that it was not prominent enough. So more invasive, the more you need what I have always called a 2x4 disclosure to the consumer before that takes place. 2x4, not in terms of measurement of the disclosure, but by the size of the board that you have to hit the person on the head with to let them know that we can keep your photographic images after you close your account and use them for whatever we want to, or we can retain your information as we see fit or shut your account down. So the more invasive or the more negative the effect to you, the more you need to disclose that prominently. Does that make sense? There's plenty of cases where those get thrown out on contractual formation because they were buried or emailed with a giant header about a new product, and then at the very bottom it said, by the way, bad stuff will happen if you continue using our service. So there, kind of answer that a little bit. We'll open up some general question and answer minutes if we have some at the end. I saw another hand because we love questions. Yes, sir.
I know a lot of financial contracts and stuff like credit cards or bank statements. They all say, we're going to share your information with our partners and so on and so forth. Does that get them around any of these loopholes?
You will have to complain to your senator on that one, because when they passed the Gramm-Leach-Bliley Act, they specifically built that in as permitted sharing if you disclose it, that you can't opt out of for joint marketing. Now, you can tell them not to market you at all, like shutting off your address or something like that if you have to terminate your email address. But unfortunately, what they'll say is one little sentence that says, we will not share your information with others except to provide services that may be of interest to you with our partners. And that magic language bootstraps what's called the joint marketing exception. So that one is permitted.
Right. Having talked about, we talked about the expanding enforcement by the FCC and the SEC to continue those acronyms that you're, I'm sure, entirely familiar with by now. Let's take a look at what a typical FTC enforcement action is. The FTC, the Federal Trade Commission, is the de facto privacy security enforcement agency in the United States. And they have been bringing enforcement actions for decades. And since 2002, they've had about 50 cases. And the number of companies that are entangled with the FTC include the who's who of Silicon Valley. Well, not all of them in Silicon Valley, because I'm going to start with Microsoft. But Microsoft, Google, Facebook, Twitter, MySpace. Just a couple of years ago, oddly enough, we were like, yeah, you would think, but the enforcement action came in something like 2013. So, Twitter, Snapchat, and it all comes down to statements that you make that you then comply with. That's the definition of a deceptive trade practice, if you will, saying that you promise to do something and not doing it. And so when you violate the FTC Section 5, the FTC comes up with an enforcement action that includes, at the very least, some of these items. That you have to designate an employee that's responsible for privacy and security, a CISO or a CP or Chief Privacy Officer. Conducting risk assessments, employee training on a regular basis, testing and monitoring the risks after you identify what those are.
And they didn't just make these up in the abstract. These are things that you're going to find in any type of info security standard that a company should have. But in a lot of these cases, when they bring in action, they're not going to have one of these elements. They may not test or monitor risks. There will be examples of companies that don't do risk assessment or don't implement and maintain updates, patches, proper types of protection. So each one of these bullet points comes from a gap where they're trying to get companies to, as part of the settlement, agree to standards that they should have had beforehand.
Right. The last two items I really want to focus on, the biennial third-party assessments. You can actually go and find Google's or Facebook's third-party assessments if they've been made public. Some of them will have been, simply because it's going to be subject to FOIA requests. And they're in effect for 20 years, almost every single one of them. There will be some variation among how this is implemented, and we'll look at how that differs with the changing technology. But your average, if there is such a thing, FTC enforcement action will require you to do all these things. And the other thing I want to mention with respect to these, the FTC and other enforcement agencies out there is the level of complexity that you see. The FTC has a chief technologist position that lasts for about 2 to 3 years, and they usually have somebody with a technology background. The current one is Lori Faith Craner. She's a professor at Carnegie Mellon on computer science and engineering. I've come across her work before simply because she's worked in the area of privacy and talked about how to make privacy policies more readable, easy to read through, kind of like you pick up your average soda can and it lists how many calories, et cetera, what it has. What if we came up with a privacy policy that did that? Wouldn't that be easy to read? Wouldn't that be more consumer friendly? So that's the kind of work that she's done, and she works at the FTC on technology issues. So let's take a look at one example. So having Uberized the presentation of these enforcement actions about ASUS, as in Pegasus, as if they're not ASUS, as in Dr. Seuss. I'm sure you're all familiar with that ASUS is the 4th largest manufacturer of PCs in the world, and this particular enforcement action concerns their wireless routers. And so they've sold about almost 918 of these since March of 2014 to 2016. And they have made some particular statements about their routers, your secure space.
Would that lead you to believe it's secure?
Yeah.
Okay, let's take a vote. Hands up. Okay.
Private personal cloud for selective file sharing. These words will come into
Does that make you feel like it would be private and selective, that you could choose who sees it?
Yeah, beautiful distinction in a second or two when we start talking more about it. And then indefinite storage and increased privacy. Indefinite, wow.
Lawyers like it when our clients say things like forever. Always. The
most complete accessible secure cloud platform. So I think I know what happened here. So somebody, a marketing manager of sorts at ASUS said, "Hey, can we just cloud wash our router? I don't know what a cloud is, and I don't know what our router does, but can we just cloud wash it?" So yeah, it reminds me of my IBM days when IBM, when they acquire a new company, it's called blue washing. You blue wash the company and you make it more IBM-like. But so that's the term that the IBMers use, so the company that's been acquired. But I think the experience on the other side is more aptly named blue boarding as opposed to waterboarding. So I think these companies, they may have thought, hey, it's cloud, it's secure, it'll sell well. Well, the difficulty was that they had authentication bypass vulnerabilities, password disclosure vulnerabilities, cross-site request forgery vulnerabilities. The FTC, this is I think one of the crucial parts of it. You enabled FTP, and it just was open to everybody without any authentication whatsoever.
But wait, that means you're selecting all. That's a selection.
Right. And that's one, and that's why we hire attorneys to defend ourselves, you see. And they were notified of the vulnerabilities in June 2013, and they issued a firmware in February 2014.
Let's count that: July, August, September, October, November. That's Thanksgiving, December, Christmas, and other holidays. January, New Year's. Okay, February.
So one of the bigger issues here is that they designed a product and they designed it wrong. You may have heard the words privacy by design and security by design. We've been talking about them for at least half a decade now. And now you have the CEO of Apple talking about privacy by design because it's made its way up to the C-suite, at least in companies that care about it. But in others, it hasn't quite made its way up there yet. And this is the FTC stepping in and saying, when you designed this product, you did not have privacy and security in mind, and it caused consumer harm. At least one individual had everything about them wiped from their local storage. I mean, I didn't go into too much detail about what the router did, but imagine some of the latest high-end routers that you'll see in the market that has a USB in, and you can stick a USB router or your external storage hard drive or whatever else. And it just wasn't built securely, and people lost their socks on this. And they weren't happy because think about all the items that you store. Credit reports, your IDs, whatever else that you need refer to at home. We've created so many, both Dino and I have Unix RAID devices at our basement where we store all that stuff so we can access it. And if it wasn't built securely, we'd lose everything. I wouldn't be happy. So that's why the FTC kind of steps in and saying, when you're designing it, you designed it wrong. Dino and I are both car guys. Think about like this. You get into an automatic car, and in order to start the car, the transmission must be on park or neutral, and you must be able to turn the switch. If the transmission is on reverse or drive, the car shouldn't start. You shouldn't be able to start it because that's the wrong position. And that's what we mean by privacy and security by design. It has to be from the get-go built privately and securely so that the consumer who shouldn't have to know how to code its or hack its router or install another firmware on it doesn't have to deal with it because they're not sophisticated enough.
Which, as you can see, is something that you can't deal with from frontline efforts. There has to be product design mentality. There has to be a product owner for something like that. So it has to be part of the design. One of the challenges a lot of companies are dealing with is let's grow this thing. They don't even care about profits, right? For smaller companies, they want to grow this thing, they want to leverage, they want to scale, and then they want to sell. And the idea of investing money in anything other than increasing market share is not particularly attractive to them unless you have something to leverage their attention with. Recent settlements are helpful, but even that doesn't get people to notice. So the idea of a compliant environment, when you're dealing with data sharing, when you're dealing with using data among multiple parties and other data sources and combining it so you can do analytics and provide your services, requires thought. It requires planning. It requires something more than just, here's what we want it to do, you figure it out. And that's what the FTC is pushing. I saw a hand over there. Yes?
Yeah, I was going to say that when people, they come out and say that we have privacy by design, yet we still see exploits and vulnerabilities in their software, they actually say that they're features.
That's the marketing people for you. Those are features. Yes, I appreciate it. And unfortunately, it is sometimes a challenge because as lawyers, right, all we can do is advise and we can help them make risk decisions. Ultimately, a business person with responsibility for the product or risk management makes that final call. Now, we're not saying there's not a lot of situations where there is a degree of risk. What we're saying is that if there is risk, you need to disclose it. Think of pharmaceuticals, right? We have a product that might kill 5% of the users, but it might save 95% of people with terminal illness. So there is a degree of utility even if there is a risk. But what do you get? A giant disclosure or a consult with somebody. So the point is simply disclose what you're going to do. I love your questions because you're nailing, all you guys are in this field, so you understand some of the pressures that we're talking about. But when it comes to ultimately making the decision, I think one thing we want to be careful about, which I'll talk more about later when we get to the nuts and bolts of what to do, is that you understand at the end of the day it is a risk decision. So if there is a risk involved, what we counsel our clients to do is disclose, because these are features that had not been disclosed. In fact, quite the opposite. They've been told that things are going to be fine when in fact they were not.
Right. And let's face it, if attorneys wrote marketing material, it'd be even more boring than this presentation. So
we're willing to admit our limits.
Let's take a look at the nuts and bolts of this ACES FTC enforcement action. And so they have to conduct risk assessment, and the risks have to include all of these items. But one I want to particularly focus on is this secure software design. Right there from the FTC's enforcement action, it says you have to make sure that the default settings are secure by design. It's not law, but if you've designed your products or if you're helping design products that are reaching the consumers that don't have default secure positions, you can expect a similar enforcement action if you end up getting the press, which, given the class action lawsuits that I talked about and the FTC's technologists on board, there's going to be a lot more press about it
now,
than
remember,
you would otherwise.
we're telling you, this is not a small slide. Remember this slide because this is what the FTC is saying, you must do this. We're going to look at a couple more examples from other regulators.
Right. And when designing and implementing reasonable safeguards, that then you after you identify your risks, you must do vulnerability and penetration testing. This is not the first time FTC is talking about pen tests, but it's becoming more of a trend. This is, I want to say, the third one, but we could point to this particular FTC enforcement action and say this is the Internet of Things. I can't believe I'm saying that to a router. It's a router. It's not a watch or anything like that. But regardless, people are going to point to this FTC enforcement action and say that it's an IoT enforcement action, and it's going to talk specifically about covered devices. This is the FTC going beyond the information and grouping in the devices that then contain that information. And I think that's going to be what's unique about this enforcement action with respect to the FTC. Moving on to another regulator with another more beautiful statement. So this is about Douala. Once again, having Uberized this slide, we've come up with all these beautiful startups. You're thinking, what does Douala mean? It's the merger of I think the technical terms portmanteau of web and dollar. You end up with Douala. So you may have heard of it if you're familiar with Bitcoin. In the beginning of the Bitcoin era, they actually were one of the first companies to transmit Bitcoin, help merchants take Bitcoin, and also take money out, exchange Bitcoin for dollars. They've since stopped doing that. But that's not what this enforcement action is about. It's also important to realize that, Douala is not very huge. They have about 650,000 users, and they process about $5 million a day. Compare that to something like PayPal, which does about $315 million a day. And you see the scope. They're a smaller company that we're dealing with. But they ran into a problem with the CFPB, the Consumer Financial Protection Bureau, that came to be with the Dodd-Frank Act that I'm sure all of you are perfectly familiar by now. And what do they say? Well, kind of like ACES. Data security practices exceed industry practices, standards. Well,
What's industry standard?
Right.
Oh, I'm sorry.
Why would you say this to begin with? Because, you are selling your services to about 650,000 users a day, most of whom, given that they're familiar somewhat with Bitcoin, are using you simply because they're techies and they understand the technology, and they don't need statements like this for them to be able to.
Does anybody know what the actual industry standard is under Gramm-Leach-Bliley for this? Commensurate to the size and complexity of the institution. It's a flexible standard. There's not a main standard. A credit union in a small farm town is going to have different requirements than a large national bank in New York City. Think about that. Because if they were to mandate a certain level, it would be out of date as soon as there was something that exceeded that. So there is a flexibility. So how do you get best in a category where there is no winner?
Right. And we talked about this from a contracting perspective last year, too, when we were talking about it. Putting something like that is like, your security standards must exceed industry standards. How do I go about even complying with that? Or you must meet industry standards. Why don't you just tell me what you really want, and then we'll agree to that, right? That's the better approach in my mind. But surpass industry security standards. Same thing, once again. You should never be making statements like that out in public. Even on YouTube. So that's going to be public too. But anyway, sets a new standard, precedent for the industry, for safety and security. Somebody at Douala really had an act. They said, okay, the only way this is going to sell is if we say it's secure. And then they said that it stores consumer information at bank-level hosting and security environments. And they kept on making these kind of statements and other gems from about December 2010 until about December 2014. Trouble was, none of these were really true. They falsely claimed that they exceeded it, the industry standards, and they had, falsely claimed that they failed to employ reasonable, appropriate measures, and claimed that they secured and encrypted everything. They didn't really. One of the details that I want to talk about here is that, once again, they're a small company, but they're trying in that they have a first risk assessment mid-2014. So they've started out in 2009. It's 5 years into being in existence. They have their first mandatory employee training in mid-2014. It almost sounds like somebody said, okay, we're being investigated by the CFPB. We should just do something about this. And then in December 2012, they hired a third party to conduct their first penetration test. So, okay, that was good practice. 3 years in existence, they do a pen test. And then they also do a phishing email attack internally. Nearly half of the respondents opened the email, where I'm like, okay, fine. 62% of the employees clicked on the URL link within the email. And then 25% of the employees, once the link opened up, tried to create an account with the website that opened. So it just keeps on getting worse. And here's the worst part. Once they found out these abysmal results, they did nothing about them. What's the point of going through all of that to find out this information that should be mind-boggling to anybody who's familiar with information privacy and security, not doing anything about it? I think this is one of the reasons why the CFPB was kind of unhappy with a regulated entity who should be treating consumer information with a little more security and privacy. They also transmitted sensitive personal information without encryption. And the other issue that kind of came to the open was that part of their they had segregated their offerings. There was their general offering, and then they had Walla Labs, and everything that was related to the consumer offering that was that had sensitive personal information was somewhat secure, but the other part that also had the APIs, etc., and the other website, the Walla Labs, that wasn't encrypted, and some of the sensitive information was also transmitting as a result of the APIs back and forth too. So that segregation, where somebody in their mind said, you know what we'll do, we'll just separate it out. We know we have to do PCI, whatever. Here's our silo, and this is all secure, and who cares about this anyway? And then data started going back and forth. And I'm thinking, you come across stuff like this in your practices where you're hoping that the stuff that's supposed to be secure is just in one area, and the stuff that's not supposed to be secure and you're not as worried about is in its own zone, but then ends up with connections between the two.
A lot of the problems that we run into with clients that we work with aren't necessarily problems with their own organization, but when they have either sister sites or subsidiaries or third-party vendors that do testing using live customer information or they create or they hire third-party contractors, things like that, where the policies that they have internally are not necessarily imposed on those other areas. And you have the data going into somewhat of an untrained, unsecure environment. That's a big challenge nowadays. Third-party access to data that's okay when it's in-house, but once it leaves there and it goes to an individual who's a consultant or to a third-party data processor or to a joint venture and it's not properly handled, that's where the problems really begin.
Right. And as a result, once again, they have an enforcement action. And what you end up finding with the CFPB enforcement action is very similar to what you end up finding with the FTC, simply because the FTC has been around for decades and CFPB has been around for less than one. So they have to stop making representations. That makes perfect sense. They have to train the employees, really, because you found out that they don't really get privacy security by design. They don't understand the concept of spear phishing or phishing attacks. They have to pay $100,000 civil monetary penalty. This is somewhat more important in that it's not a large amount. We're not talking about a big company. And you may have heard about regulators adjusting fines of the subject of the investigation based on the size of the company. So they'll say, we'll issue the $4 million fine, but based on the financial condition of this startup, we're just going to make him pay $1 million of it, because if they made all four, they'd be out of business. And we really don't want to be the enforcement agency that just bankrupts startups. We just want to make sure that they understand how to start up a company in the first place. But for an enforcement agency, you look at FTC enforcement actions, and while in some areas you will see fines right away, when Google had its first enforcement action, they didn't have a fine. And then they had a second enforcement action. It was about Safari cookies that they were automating and they should not have been placing, and they were smacked with $25 million of fine. So this is the CFPB setting a precedent saying, if we have to come into this area again and we have to have a privacy security enforcement action against a regulated entity, you can at least expect to pay for our attorney's time in having investigated you. So I think this will be the case going forward, CFPB. I believe this is CFPB's first privacy security enforcement.
But one thing that's different about this is that the CFPB regularly audits institutions that are under its jurisdiction, and this provides an example for routine audits of any type of a regulated entity where the regulator comes and does a periodic annual review of what you're doing. This is going to be a chapter of their audit, right? It's going to be more than part of the regulatory audit. They're going to raise information security procedures to an issue of controls, whether they have adequate controls or not. And then if they don't have, and if they see there's a problem, then it becomes a referral for an enforcement action. And that's where you're going to get hit a lot of times. Not a customer saying, oh, I think there's been a data breach because I have a bunch of fake charges or there's an account set up in my name, but just from the audit itself, from within the standard audit practice. I saw your hand. Yes, please.
You may have answered the question, but I was wondering how a small company can come to their attention. Surely they don't have the resources to audit at this level every one of the institutions that come under their.
No, there are some where they have unique jurisdictions. So, for example, not just typically for banks, it's based on asset size and above, right? The size of the bank. It's usually for larger banks, but there are companies that are either regulated by them because they're a substantial provider, they're a service provider to banks, or types of industries like student loan servicers, things like that. So there's subcategories of organizations where they are regulated by the CFPB by the type of regulation, like maybe only the CFPB has authority over it, or it's a referral from a state auditor or somebody else auditing them, or the type of business that they do. So even though they may not be a true bank, they might be a collection agency, they might be a student lender, things like that. So there's other areas of jurisdiction. This does provide an example, though, for FDIC enforcement, for National Credit Union Association to enforce against credit unions. So it again is a standard template. We really don't see a lot of difference here among the agencies. There's a bit of a harmonization of what they're doing. The challenge is when you see there's absolutely nothing done in particular areas, and there is a lot of pressure from some organizations, again, fast-moving startups that are well-funded, to grow as quickly as you can. And if they don't have adequate management in this area, which does happen, the point here is that even smaller companies might be subject to both audit and then eventually fines.
Right. And go back to the point I made earlier about the technologists, et cetera. I do not believe that CFPB has got a technologist on board, but what they do have is referrals. The FTC and the CFPB and other regulators will have referrals from the general public about things that are going wrong in the marketplace. If I'm not mistaken, Google's second enforcement action, the Safari cookie, would not have been easily found unless a security or technology researcher went in there and notified the FTC about the goings on. And I believe this may have been one of those scenarios. But at the same time, even though they are small, they do work with as an agent of an Iowa bank to be able to provide the financial services that they do. So they have some solid connections to other larger entities in the marketplace.
Like I represent student lenders and debt collection agencies that are subject to CFPB audit.
So could a competitor have turned them in?
That would be awfully hard for a competitor to get that level of information without getting trade secrets, because that deals with the organizational structure of the company. I'd have to find out about that. I didn't know the source of the referral on that.
But it kind of gives us, the next point I want to make kind of ties into this, is that there was no data breach. So Dwala wasn't breached in any shape or form, unlike ACES where people lost their files and you could easily access whatever was stored in the USB or the FTP portions of the router. That wasn't the case with Dwala. It's just their security procedures lacked, and they should have done more. And you are seeing more and more of this with at HIPAA as well. We're going to touch on a little bit of that as well, but I think this enforcement action is important from those perspectives that you get a fine. It's the first private security enforcement action. They are somewhat sophisticated, and you don't necessarily have to have specific harm to the consumers for them to institute an enforcement action against the company. HIPAA being the next issue is in these cases, you usually have some sort of harm, in that both of these cases arose when the entities had to notify the Office of Civil Rights of the Health and Human Services of a breach they had involving more than 500 individuals. You may be aware already that HIPAA high-tech regulations require you to notify the regulator, OCR in this case, of a data breach that occurs if it includes more than 500 people at the time it happens. If it's less than 500 people, you notify them at the end of the year along with your other breaches, if you will. And in both cases, the OCR went and audited these companies, looked at their policies and procedures. And in the first one, with respect to Feinstein Institute, They were rather large. They had 21 hospitals, 450 patients, and they had filed a breach report in 2012, and it was the beginning of this year when these fines came out. So you can almost think about 3.5 years of time that it takes between a breach happening, a regulator going in there and start auditing, and then enforcement action coming out and becoming public. What ended up happening in this case, in the first one, was the laptop containing protected health information of 13,000 patients was lost. It included names, dates of birth, social security numbers, your average breach that I'm assuming that you're been subject to in your past experience. And what they what OCR found out was that despite Feinstein's size, the number of hospitals, et cetera, that they were working with, they had very limited security management processes, and it was limited, incomplete, and insufficient in scope. And they lacked the policies and procedures to govern the receipt and removal of laptops. So if that laptop, you don't really govern what's really on it, and it's not encrypted, then, and it's lost, and you violated 5-6 years ago, you may not have had an enforcement action. Now you're going to have an enforcement action, and you're going to pay some massive fines of $3.9 million. A North Memorial Hospital also happened with respect to the following breach report that the hospital filed with the HHS, and that was in 2011, September of 2011, and that included 9,497 individuals. What they found out was that the breach included a business associate of North Memorial Healthcare, and the business associate had access to a lot more information than they should have, and there wasn't a business associate agreement with this company. They had access to 289,000 patients' information without having a business associate agreement in place. That is a big problem. If you have a small company that accesses one or two individuals without having a business associate agreement, a regulator may choose to overlook that. But when it's close to 300,000 patients' information that a business associate is accessing, you should ensure that there is an agreement in place, and you should ensure that they have the appropriate privacy security procedures in place for the security of that information. And as a result of that, they ended up having to pay a fine of $1.5 million. One of the other things that's coming out lately is, I'm sure you've heard of the security reports or the breach reports that come out regularly. Verizon is one entity that, releases annual reports on how breaches have happened and what the sources are, et cetera, that I think somewhat informative. But this is one example of the California Attorney General, Kamala Harris's team, who's released a data breach report. It covers the years of 2012 to 2015. And what they're doing in this case, and what I think is important and shows basically expanding enforcement by the state regulators, having moved away from the federal regulators, is that they say, here's what we deem to be reasonable security, regardless of what industry you're in. And they point to the Center for Internet Security's critical security controls. I wasn't entirely familiar with that until I heard the SONS 20. SONS Top 20 is what this used to be called. And it's your average information security top 20 list, inventory of authorized, unauthorized devices, securing configurations on workstation servers, continuous vulnerability assessment, remediation, maintenance. This goes on, and I'm sure most of you are familiar with those. But they're pointing to them and saying, we expect you to follow these, implement them, and follow them. And if you do, you will be following reasonable security measures. But if you read between the lines, what the Attorney General is basically saying is, if you do not have that, then you don't have reasonable security measures in place. And that is one of the first areas of the State Attorney General coming forward and offering what they mean by a reasonable security. But they also...
This is one thing I want to mention. This is a good report to read because it's somewhat of the future of state regulation. It's a very good synopsis of the current state of affairs for state regulation of information security. If you think about what we talked about last year with proposed federal regulation of data security, and what we presented in 2013 about proposed regulation of data security from the federal government, 10, 209, 208, the other presentations we've done, it's always on the way, it never gets here. One thing that's interesting about all those proposed federal statutes, if they're going to federalize data protection, they generally have one thing in common, which is unusual if you're dealing in progressive politics. Normally progressive politics says, we'll have a federal law as a baseline, and then we can add state law if the states want to have more consumer protection. This is technology, which is much more funded at the lobby level. If there's a federal data breach law, all of the drafts generally had one thing in common, which is preempting states from more regulation, even when it was controlled, both houses were controlled by the Democrats, which shows the power of the technology lobby to say, we would like a one-size-fits-all data protection statute across the country, because it would make it easier for our business. Now, that's obviously a choice that probably wouldn't surprise you, but what I find very interesting is that every one of those bills has a couple things in common, that being one of them, a federal cap, a federal standard across 50 states. The other piece is that those would preempt your ability to sue them. Think about that. What we've talked about in all of these federal statutes with all of these agencies is the fact that you can't bring a lawsuit generally for a lot of these. You'd have to refer it to your regulator, and either the Attorney General for your state or the federal regulator would have standing to bring something from the CFPB or the Federal Trade Commission or something like that. There are class actions and there have been settlements for data protection, but they generally are unique. They're not proliferating to the degree that would be a commercial incentive for companies to change their ways. So what you see here with state laws is, especially with California, there's a large technology base there. So they have taken the approach of regulating as much as they can in collaboration with business interests to articulate what the rules should be so that the state can enforce its own privacy in addition to whatever federal law requires. So it's a good read, and since the federal pending bills really don't seem to be going anywhere, what I think you're going to see is more and more state regulation and proposed state regulation that will create a bit of a patchwork where some states will say, here's our rules for electronic and printed data, and we'll treat them the same if that information is compromised. Other statutes might say, well, here's our state law regarding data breach and data security standards, but it wouldn't apply if the organization is regulated by Health and Human Services, because it's PHI, or a banking regulator or something like that. And it's an interesting area. I think this is kind of where we are today right now, state regulation, expanding federal and expanding state.
Right. And think about where we have come to has changed, where the state regulator is saying that you have to implement, you should implement multi-factor authentication. They're not saying you must. You're saying it's a good idea to do so. And the other thing they're recommending in the healthcare sector is they're saying you should encrypt portable and desktop devices. The world has moved on from having encryption for desktop, laptop and mobile devices to just encryption for everything else. So you haven't gotten there yet. The regulators expect you to do so. You'll recall the Chase breach that happened almost 2 years ago now, I want to say. And I believe one of the reasons it happened was the hackers were able to find one server that didn't have two-factor authentication. And it may have been the only server within Chase that didn't have a two-factor authentication, but that allowed the stolen credentials to be used and Chase to be hacked. So, world is moving on to multi-factor authentication. And it's also a good idea for consumer. I'm sure, you having the security background that you do, you already have that, but hey, we do two-factor authentication. We do encrypted everything. So, but luckily we're a small law firm. I mean, we have that liberty.
So what do you do? Remember when I said earlier that at the end of the day it ultimately is a risk decision? What are some things that we can do now that we've gone through the parade of horribles of victims along the way? How do you protect yourself? Well, the first thing to do is to prepare for this. And I always find it interesting, whether it's a large company or a small company, there's always opportunities to improve. A lot of times stuff gets built up and everything looks good, and then there's a merger, or there's a sale of a business, or it gets divested. And all the people that put together a very nice sandcastle, it ebbs. The tide comes in and it goes away. So it's like going to the gym, right? It's a process. You have to stay with it to stay strong. But the first things that you want to do is conduct a privacy audit first to find out where information is flowing. Where are you collecting information? Where is it being stored? How is it being secured? And then who are you sharing it with? Those are big categories to identify. Identify the areas, the types of data you collect. Is it health data? Is it financial data? Is it images? Is it audio recordings? Is it government information? And then identify where it's being stored. And if you have your own data center and you physically know where it is, more power to you. But if you hire it out, is it going to be at their location? Is it geolocated? Or is it anywhere? Is it their Philippines data center? Is it in China? Where could it be? So it's very important to identify where information is collected and stored. There are some countries that have data localization laws. So if you collect information about people that live in their particular jurisdiction, be it Russia or British Columbia or something like that, certain businesses must keep a copy of that information stored locally or limit access to that. So location, even though the internet allows everybody to see everything everywhere, there are some rules, and geography still applies in a number of cases. So you also need to identify who can access it. That can be third parties that you do business with that are providing services to you, whether it's analytics or storage or business continuity. It also includes employees, right? The janitor of a company does not necessarily need to have the ability, just because he works at that company, to turn on a computer and see the HR files. That's an obvious case. But what about HR managers? Should somebody in one particular division be able to see HR files of people in others and performance reports and things like that? It does happen, doesn't it? And so you need to limit accessibility to that. It's very key to limit that. So because one of the challenges we have, right, is data proliferation. It's all over the place. I think we deleted it. I think it might still be over here. We'll delete it there too when we get to it. But then once you build the fort, you need to do intrusion testing, right? We saw examples of that. Hire third parties to come in and see if they can overcome your security methods. It's not just enough to build the house. You need to test it. You need to identify if vulnerabilities are found, right? Voila. And then you need to make those changes as soon as reasonably practicable. And then you need to update your standards, and then you need to train people. You also need to develop an incident response plan. We've done this with companies before where they know it's going to happen, so they work with us to identify who are the people on the team that will handle it. Will there be somebody from PR involved that can speak on behalf of the company? What are the steps that must be taken to identify whether or not there was a breach that occurred or a compromise that occurred? And then who needs to make the decision of whether there's a notification or a change required of that? So that's very important to do that. And then the other thing is develop customer communications. It would be really nice to have a draft in advance of a notification to your customers that's pretty much complete except for a description of what actually happened. So we've had some companies that have done that in the past. And then you have to anticipate regulator notifications if required. Not just federal regulators, right? We all know that you have to notify OCR if there's an HHS breach over a certain threshold. But there's state regulations, right? There's state laws that would require you to notify the Attorney General, perhaps. Or in some cases, there may be a Department of Banking regulator if it's financial services. You have to notify in certain cases and let them know because you might choose not to report, but you have an obligation. In other words, you might choose to not notify consumers that their information was improperly accessed, and you make a decision, no, there was no risk of harm. But there might be a state law requirement that you notify the regulator of what you did and how you investigated it and how you came to that conclusion so they can second guess you if you're a regulated entity. So it's important to remember that you have to notify regulators in certain cases, and in some cases in a very short amount of time. In most statutes, you have a reasonable time to investigate whether or not a breach occurred. Is that 6 months? Is that 3 months? Is that 30 days? Are you allowed to keep it quiet while you notify law enforcement? In some cases, that's going to be yes. In some cases, that requires law enforcement to have accepted an investigation. You can't just leave it out forever and use that as a drag to not notify anybody. And there are some cases where companies have waited a very long time before they notified customers to protect themselves. And then you need to select a media response team. Sometimes you're going to have to issue a press release. Sometimes there needs to be a statement made where people will be able to read it and they're going to respond to it and they're going to call and they're going to be angry and they're going to notify the Attorney General and they might even try to sue you. So you have to have a voice that speaks on behalf of the company. But it sure is a lot better to have that planned out before it happens. And then once you go through and you identify where data moves within the organization, you need to have policies. And there's two kinds. Privacy policies that are HR documents that identify how information is supposed to be cared for and treated in your organization, including deletion, including who has access to it, including what happens if somebody does something inappropriate and how disciplinary action is taken. That's the internal document that is a company procedure. It's part of their corporate governance. It's an HR. You have a policy, and then you have requirements that are disclosed, and you train people on how to do that. Data management requirements. But then there's also external privacy notices, and those are the ones that you share with people that you do business with, or your customers, or you post on your website before you collect that information. If anybody says, well, we're a B2B organization, we really don't have a lot of people that use our information, do you take job applications? There you go, there's personal data right there. So you need to identify how you're going to use that information, who you're going to share it with while you go through and determine whether or not their background is suitable for employee there, and whether you're going to call them back a second time, and if you're going to dispose of it. So that you have internal rules that you need to put down so that people in the organization know how to deal with it. Don't forget, not just your own employees, but contractors and subcontractors. So you bring somebody in who's a one-off contractor, and you give them access to company information about your customers so they can do performance modeling and do analytics or something like that. Are you going to let them take it home? Are you going to let them keep it on their server? Are you going to have rules, or are you just going to let them do it while they're in the office, or have a secure token to come in? It's not just employees that have to abide by the internal privacy policy, but you need to take those policies and impose those on non-employee contractors as well. You integrate you have to develop an information security policy. I kind of hinted at that, which is very important. We always recommend that you develop yours in parallel with some type of a standard that is common, whether it's ISO, whether it's NIST, and a lot of times our clients will pick a standard because it's favoring an industry they want to do business with. So if you're a government contractor, receive government payments or service government assets, NIST is always handy, especially I think HHS favors the NIST standard as well. You can use ISO. There's other ones you can use. We don't want to do a homebrew, but you want to do something that the closer you are to identifying procedures that are generally accepted at what I call the Roman numeral level, not necessarily the small permutations that are customized for your business, but at least you're touching on all the bases. That will help you establish that your information security policies are reasonable as a starting point. And then you integrate those with the HR policies, right? What good is it to have a company manner of treating business information and customer information if you're not actively communicating that to new hires? And then if there's changes that you make because of an incident response or an enforcement action, you need to have periodic retraining of those people so that all the learning that you have can be updated, and the people that work for you can be enhanced so that next year you don't have the same problem in theory. You need to have a data security team, both for physical and system security. So the boxes and the devices that are resident in your organization, and the iPads and the BYOD devices that you allow, that you physically approve the use of those, and that they're managing them properly, but also the system security in terms of the connections, in terms of how you're allowing people to either access information or send it outside the organization, if you do at all. Vendor management, right? I talked about privacy policies for internal use and storage and deletion of information. You take those policies that apply to yourself, and then you have to create a document where you add those policies and the care, feeding, and protection of that customer or personal information, and you impose that as a schedule on any vendor contracts. Now, I understand there's a lot of negotiation that goes back and forth, because if you're an organization and you're mature and you have something like that already for HR policies, and you have a document that is a document that you already have to attach to an agreement with a potential vendor, a lot of those potential vendors will say, we can't have 65 different documents with 65 different companies and create 65 standards. Here's our company standard documentation. Okay, I understand that there can be differences, and those are both valid arguments. You need to protect your own information the right way, and the vendor needs to be able to sell you a service at a reasonable price. My point is, as you go through and look at both of those, there probably is a lot of overlap. There will be a lot of things that you need to do a gap analysis. Is there something in that contract that would say that because we require 25 steps for our information, they're only covering 18. If there's a gap of 7 things that they're not doing for your data that you really feel are important, then you have to make a decision. Is it worth it? Or are there other ways to get that type of protection? What happens, for example, if the vendor gives you all the promises that you want and agrees to take your document as its guide for protection and data security and data policy, but then in their contract it says we limit our liability for breach of this agreement to a refund of the 3 prior months' fees paid? That's not a lot of money if you're dealing with one of these settlements, is it? Especially if it happened. What about notification? Is there a clause where your vendor notifies you of an incident, not a breach, but an incident? You want to determine if there's a breach. You don't want them determining it. Plus, if you're a vendor, I want to get that information. If it's a 0-day vulnerability, okay, that's a cost of business. And if you're hacked and you have to notify the company that you're doing data processing for, okay, it's part of it. Let them know. Get them involved in it quickly. You want the decision on notification pushed to them because you don't want to come to a conflict. Ultimately, the data owner should have control over that decision. But you need to read those terms, and you need to make sure that what the left hand gives, wow, we got all this in the service level agreement. The other hand doesn't take away. The liability will be limited to $0 or $100 or something like that. Be careful about that.
Now let's move on to international privacy issues. You may have seen this in the news recently. It relates to the program called US-EU Department of Commerce Safe Harbor. And the reason for the Safe Harbor, the existence of the Safe Harbor, was the fact that the European Union had a completely different set of laws with respect to privacy and security than we do in the United States. We have this sectoral approach to privacy, as we talked about. We have these many different regulators, whether it's in the financial area, healthcare area, or if it's relating to children's personal information or financial information. We have different regulators, and it's a patchwork, and I would argue that the patchwork is just as strong as a unitary approach, if you will, to privacy, where you have one regulator in the country that deals with the protection of all personal information. That was the approach that the Europeans took in 1995 when they passed their EU Data Protection Directive. And given that number of multinationals that are operating both in the European Union and the United States, and they had to pass data back and forth, personal data relating to both their customers as well as their employees, they needed a legal way of ensuring that the data left the European Union and arrived in the United States in a secure manner. So we created this framework, the EU Safe Harbor, and this was administered by the Department of Commerce. It's an odd place to put a privacy program, but the Department of Commerce in the United States deals with these commercial issues, and the European Commission agreed to it, and the Federal Trade Commission enforced it. So when you think about the Google enforcement action that I mentioned earlier, the Facebook enforcement action that I mentioned earlier, all of those included violations of the Department of Commerce Safe Harbor program simply because of violation of the FTC Section 5 that says, you're going to protect the privacy of your consumers properly. If you violated that standard, then you will have also violated some of the protections that are built into the Safe Harbor. As a result, we've had enforcements of the Safe Harbor in the past. But what happened afterwards was this individual by the name of Max Schrems in Europe started this group, Europe versus Facebook, given all the privacy brouhaha that arises in Europe whenever Facebook is mentioned, basically. And he was trying to start a class action lawsuit against Facebook. That didn't really happen, but what ended up happening is there was a lot of investigation of the privacy of Facebook, especially with respect to the data transfers from the European Union to the United States. And Facebook was also using the Safe Harbor, and it went all the way up to the European Court of Justice, which is kind of like their Supreme Court, and it was held to be invalid. And so all this program that many multinationals were using as a form of transfer for personal data from European Union to the United States was invalidated, and they had to come up with another framework. And recently they did. What they ended up doing, once again, you have the Department of Commerce on one side, negotiating with the European Commission, who then has the Federal Trade Commission enforce these standards. Once again, very similar to what we had before. But then you have the Department of State that kind of acts as an independent arbiter in the event that complaints arise that relate specifically to intelligence gathering, because that was what provided the momentum for the invalidation of the Safe Harbor, the Snowden revelations, if you will. And they decided to call this the US-EU Privacy Shield. And every single time somebody mentions Privacy Shield on Twitter, there's certainly some sort of Captain America thing just happening in the pictures. It's inevitable. I don't know who came up with it. I don't know who we're shielding from privacy, but that's the name they came up with it. And just yesterday is when the Article 31 committee that is in charge of approving this approved it with some of the revisions that'll come out. And it will allow companies once again to transfer data from the European Union to the United States. It's been taking up a lot of space in the media lately simply because of the amount of impact that it would have on multinationals, on Facebook, Google's, everything else, and the amount of work you have to do in the background to be able to transfer this data, because there are all these alternatives that you could use, all of which are either very expensive or very complex to administer. And I don't want to go into too much detail of this, and if you are, feel free to catch me afterwards to ask any other questions. But one of the other issues that I want to talk about, at the same time as this was going on, given that the Europeans had passed their privacy laws back in 1995, it was time to update it, and they had been working for years to update it, and they finally finalized it around December and published it in May 25, and it will go into effect in 2 years' time. And when it does go into effect, and if you happen to have some sort of European subsidiary, or you're transferring personal data relating to European individuals, and you're somehow subject to that law, in order to notify a breach, you will have a total of 72 hours. When Dino was talking about what is reasonable, in Europe, that's just 72 hours, beginning 2018.
Yeah, one of the challenges that they didn't like is the privacy statement said we won't share information, but then they would give information to the national security agencies. And the idea would be that that's beyond the scope of a permissible sharing regardless of your disclosure. One thing that's a little bit different is that to pass this, Congress, although people think that Congress isn't getting anything done, they got one thing done pretty quickly, which is the Judicial Redress Act. And that gives jurisdiction to EU citizens to sue for violations of this, for improper sharing.
They don't really get anything more than what we have. If they believe that somehow their rights have been violated, they get to go to the Department of State. The Department of State goes and works with the intelligence apparatus in the United States, and they get GLOMAR saying, we looked at your data. We're not saying we have it, or we don't. But if we had it, and if there was a violation, we addressed it. And if we didn't have a violation, and if we didn't have your data, we didn't do anything about it. So
now go away.
So now go away. That's the kind of response that they get. But that's no different than if you went to the NSA and said, can I have my data, please? Under a FOIA request, and they would say to you, we can neither confirm nor deny that we have your data, but if we did, it'd be confidential, and we would be able to give it to you.
Which, just for comparison, is that the European agencies can do that to their own citizens with impunity. They already do it to their own.
And many people who look at this, the Facebook versus Europe, not so much the individual, I think the way he brought his litigation was more privacy related, but the European bureaucratic apparatus that looked at that mainly from a trade protection perspective. It was undeniable that, our cloud offerings, if you will, are doing so well, and theirs are just not getting off the ground. And one of the best ways to ensure that their industry gets better is to make sure that the data stays there. And so that's what you start seeing spreading globally. Data localization laws. Keep my data here in Europe, and don't transfer it to Europe or Russia or wherever else. And the other issue, once again, is the high amount of fines. That is definitely going to be... go ahead, before I move forward.
Talking to you about globalization of data, I don't know if this is really within the scope of what we're talking about. What about I don't even know if it's been determined, but isn't the federal government trying to get Microsoft to give them Irish data?
Right. Yeah, that's one of the issues that I think that was definitely in the background of the negotiation of both this General Data Protection Regulation, which is the overarching privacy law, as well as the arguments against bringing down the safe harbor. That hasn't finalized yet, but if you are a federal regulator, you will argue that you have jurisdiction to access any data that any individual that you have access to in the United States has. Microsoft's based in the United States. They have a server in the European Union where the data is stored. Microsoft should have control over that data in Ireland to access the email. And that's what Microsoft is basically litigating, to be able to access the email. That hasn't concluded yet. It will take some time. But the tech industry is most definitely behind trying to revise the Computer Fraud and Abuse Act of CFFA that tends to get abused all the time, how that allows individuals to have access to data, and how information can be accessed abroad. They want certainty around these rules, but unfortunately, if you are in the business of collecting this information, as the government is, for good or bad, you're going to want to access that information. That likely will not be resolved for some time, and the difficulty that we're going to be having from now until eternity is how to get certainty around. That's not going to come about because we haven't resolved the underlying issues with respect to government access to personal information. We have it here in the United States. Europeans have it, and there's really no easy way out. It's just that the corporations are stuck in the middle, kind of like, two parents having a divorce and kids are there. They haven't done anything wrong, but they're there. And so the corporations are there. They need to give access to Microsoft. At the same time, they need to abide by their legal obligations in Europe. So it's a challenge, and I don't have an easy answer there for you. But
we'll bring it up next year. We'll let you know where we are.
Right. Fines of 4%. That is big, and we were scheduled to go to a conference in Brussels that got disrupted by the France events, but those regulators ended up coming to DC. And so earlier in this year, when we were talking to the European regulators, this is the one thing that they pointed to. They were talking about a Google executive who was talking about what keeps you awake at night, and his response was a European regulator with the ability to fine the way the American regulators do. And I think what he was specifically talking about was the Google's fine of $25 million that a European regulator at this time cannot really sanction against, right? But when this law goes into effect in 2016, 4% annual turnover, you're a $100 billion company. Imagine a fine of $4 billion for a privacy regulation. It's unheard of. You will probably see more of it, probably not $4 billion, but you will see American-style fines coming out of the European Union and grabbing headlines. So, we've gone through most of this, so I don't want to repeat it. But having talked about all these risks, it's always good to prepare and have tabletop exercises, especially with respect to breaches, because it's not something that you're going to be ready for when it happens if you haven't prepared for it in advance. And I will leave you with this. I think this relates to somebody who asks you to email something to them when you've already emailed them 3 times. And the surprise is if they find it, not whether you've actually sent it to them. But
so if you'd like to get a copy of this presentation, let us know, and we'll send you a surprise.
We'll airdrop it to you. All right. Well, thanks so much.
Thank you very much. We have time for questions if you'd like to come up afterwards. We want to stay up on time, so I'm not sure where we are otherwise. So if there's to keep on track, we'd be happy to talk afterwards.
Yeah, about 5 minutes if you like.
Do we have time? Well, if that's the case, we'd be open for questions if you'd like to ask some now. Oh, these aren't, by the way, this isn't legal advice. But it sure might sound like it.
Good.
I'm a little confused about what is driving the privacy effort. We have a definition of personal information in various state laws. But I noticed that the Federal Commerce Commission is involved in this. And it made me wonder if some of those federal regulations, commerce is required in order for the law to be violated. So, for example, if Facebook starts out with no profit, it's just a voluntary sharing of information. Is commerce involved, and would it have been regulated without the state privacy laws?
There's a lot of commerce that occurs without profit. The idea of a commerce clause analysis generally requires it's interstate commerce, and almost everybody is doing interstate commerce by way of sending emails, posting stuff, and intentionally interacting with people over state lines. So it's pretty easy to become federally regulated. I mean, right now, Uber has not made a profit, but it's still regulated, right, by the FTC. So you can have plenty of incredibly highly valued companies that have no profit, but they're still interstate commerce. And the states, there's 2 things that attract regulators. Number one, a sense of worth, bringing value by enforcing this regulation because I'm doing something good. At a minimum, to justify my budget request for next year for more staff and more enforcement because I found some bad companies that were doing bad things. The other is if you're an elected official, like an attorney general, it's a noticeable thing where you're protecting people against breaches of their data and bringing in recoveries. And a lot of people do refer data breaches to their attorney general and stuff happens. They do bring recovery. So the states have a huge space to regulate transactions where they're either within the state or they involve amounts that are so small that the federal regulators don't really have time or resources to go after it, and there's not enough to pay a class action lawyer to represent the class. So they do fill a valid need. There are companies that aren't paying enough attention to it and aren't responding quickly enough. So I'm not debating pro or con. It just is what it is. But it's definitely something that a government agency can do that seems openly beneficial to the people that are voting for them, and do benefit them as well.
This goes back to the jurisdiction of the Federal Trade Commission, if you will. So every single regulator's got a jurisdiction that is determined by statute to a certain extent. And you can read the Federal Trade Commission's jurisdiction, and it extends to those entities that are in commerce, primarily. But then, that's also been litigated to a certain extent. There is one case, the FTC versus American Dental Association, ADA, and ADA was a nonprofit, but it was held in court, and FTC argued that it was working for the profit of its members, and as a result, it could be brought under jurisdiction of the FTC. So even though the Federal Trade Commission we think about as regulating commerce, competition to a certain extent, its jurisdiction is expansive. The Attorney General's jurisdiction is not necessarily created by statute, to my understanding. They don't have to regulate commerce. They can take actions against harm, period.
Very similar to the FTC's jurisdiction. States have many FTCs that prohibit deceptive practices or unfair practices, and they can define unfair in a number of different ways themselves. Like in the state of Ohio, you can't collect attorney fees on consumer contracts, but that's because of a Supreme Court case. You'd really have to look hard to find where that is. But if you had an electronic contract that had that language in it, and it was an Ohio customer, and they had that in the contract, it would be a violation of the state's Consumer Protection Act.
You definitely answered the commerce side of the question. Still struggling with the privacy piece and wondering. I don't know that privacy is a guarantee of the U.S. Constitution, but it's a certain state constitution. It made me wonder if that was behind some of the resistance to federal law.
No, very little.
I would argue the constitutional analysis is unnecessary with respect to the privacy laws, simply because the Constitution does very little with respect to your interaction with private individuals, and this is what we're talking about mainly, right? So there's the Constitution. Your constitutional rights are mainly your rights against the government, right? You preserve those rights for the individuals, so the government doesn't have them. Your First Amendment, Second Amendment, whatever rights, right? But Facebook and privacy, First Amendment, is unnecessary and irrelevant. You don't have a right to go on Facebook and say whatever you want, regardless of the fact that this is a free country and you have First Amendment right. It's just a right forum, because that is a private forum. For the same reason that you cannot go out into a private mall and start doing whatever you want because it's a private area. Rules may be different in the post office, right, or a federal land. But what is the impetus with respect to privacy and regulation of it, I think, is what I hear you asking. And the reason for that is mainly harm and data breaches. The watershed moment in my mind for the regulation of privacy and data breaches goes back to, in 2003 breach, where, the individuals weren't notified, and California passed its law saying, well, you need to now notify individuals that their personal information has been stolen, because if the individuals do not know that their social security numbers, driver's license, etc., is out there, they cannot protect themselves from that harm.
But hit the pause button for a second. You see what that statute did? That presumed they didn't have to say anything before that statute was passed. So when I started dealing with internet law a few years after I graduated from law school in the 90s, there was no requirement to have a privacy notice. So if people got your service and there was no privacy notice, then you really didn't have a claim. Where you had your first claims where the company made a statement about it, and that statement proved untrue or was misleading. It didn't have to be on point, but if it led you to believe they were going to take care of it and they didn't, that's what happened. Then you had a problem. So a few states made statutes that said you have to disclose a description of your privacy practices on your website. So states started doing it, and federal regulators began doing that. Like for banking services, they required that you have that. But without those laws saying, thou shalt have a notice, there was no requirement. It's just the only problem came, the only jurisdiction happened when you said something false or misleading. And then states added a layer of breach notification that if unencrypted information was improperly accessed or viewed, then you had to notify customers to allow them to protect themselves from identity theft. But without that layer of laws, there wasn't a requirement to say squat.
Yeah, one thing I want to add that I kind of forgot to add in the beginning of the presentation when we were talking about state issues was we talked about state breach notification, where you have an obligation in 47 states of the 50 states plus a couple other jurisdictions that are not states to notify individuals of data breaches. And the definition of a data breach and the definition of personal information changes. But what we also happening in the last few years, ever since Massachusetts passed its data security law, is that states are creating an obligation to make sure that the individuals that are collecting, the companies that are collecting personal information and the agencies that are collecting personal information reasonably secure that personal information. That is different than data breach in that where the law says, if you have a breach, tell me. Now the law is saying, here's how you secure the information. And Illinois just revised this law to say that specifically. Have reasonable security policies, procedures in place to secure the data. So we see our laws changing from regulating the harm to also doing stuff to prevent the harm in the first place. Go ahead.
Yeah.
I just want to tell you some takeaways, plus my question was kind of towards his. One takeaway is that risk assessments give you calories, and the second takeaway is that apparently Dwala's 256 line feed carriage return cipher isn't secure, so I got to go back to the drawing board. Also, my biggest one is that whole European-U.S. union. It started making me think about companies like Amazon, Etsy, and eBay, who are already involved in commerce, and how will that actually mess with what they're already doing I thought was working. But it seems like that'll give them another bit of regulation that they're going to send out to their people.
Right.
Don't know.
Well, which one of those? You gave us a few topics to cover.
The latest one. The latest one that's in legislation right now.
Oh, about that, yeah.
The privacy shield?
Yeah.
Yeah, this is affecting a lot of multinationals. It's affecting the Googles, Facebooks of the world. It's affecting Amazon, probably not Amazon Web Services, though AWS, if you're using it for that purpose, you probably not, simply because Amazon will argue we don't really access personal information when you're using AWS. When they're selling stuff, when I think about the law that this change in law affects, I don't mainly think about Amazon, but I think about Facebook, simply because that's where the litigation started. Where are your data centers? How are you going to try to put them together where you can work out the most analytics so you can serve the most ads and make most money? And if you're unable to bring that personal data here, then you have to do everything there. And that changes your IT structure completely. And that's basically what data localization laws are doing, is where until about this law passed, where most multinationals would have liked to centralize all their IT infrastructure in one location or multiple locations in one jurisdiction. Now there is an urge to separate it out so that you can comply with these laws. And one example I can give you is Microsoft recently announced, around the same time as when the Privacy Shield came out and the safe harbor was struck down, that they were going to create a new data center in Germany that they were going to own, but that they were not going to administer. Deutsche Telekom, who's a German company, was going to administer it for them so that they would not be subject to the kind of subpoenas that Microsoft's subject to with respect to Irish the email solutions. But the problem always is, given living in the global world that we're living in, Deutsche Telekom owns most, if not all, of Verizon. So I'm not going to serve a subpoena to Deutsche Telekom in Germany. I'm going to serve it to them here in the U.S.
Wouldn't a BAA get around that?
I'm sorry?
A business associate agreement from Microsoft to
the equivalent of standard contractual clauses.
That would just get around all that.
Yes, I mean, I think Microsoft's got a little bit. They are thinking about this a little bit more sophisticated manner than I'm explaining it. So maybe there is more to it than that. But in terms of trends that we're looking at, we're seeing a lot more data localization as a result of laws like this.
If you really want to get down in the weeds, there are 3 ways you can transfer information: standard contractual clauses, binding corporate rules, or the safe harbor. And the easiest was using the safe harbor, where you do due diligence, make representations, do a filing, and bake it into your contracts. What happened after that, after the safe harbor was stricken down because of NSA access to data beyond what EU law would allow, everybody immediately jumped into standard contractual clauses, which are kind of like EU privacy BAAs. You take the law, you bake it into the agreement. The problem is that they're subject to the same challenges and the same problems that the safe harbor was under. So the idea would be we need to start with a fresh slate, and so the EU is withholding its judgment and withholding enforcement pending the outcome
Right.
of the shield. So the shield, in essence, would be Safe Harbor 2.0. The idea being that it would give additional redress to EU citizens that would still allow, by giving them increased disclosure, increased redress, the same problem for Safe Harbor would have applied to PAAs. So we needed this to get a degree of certainty approved by the EU Commission.
Yeah, the underlying issue is, once again, government access to personal information that the Europeans don't like.
So that's why you told us next year, same that time, same that channel.
Right.
Yeah. Good questions. We really appreciate it.
Harold, thank you.
Yeah, thank you very much for
appreciate
your
it.
time. Thanks for letting us be here today.